The year is 2026, and you pride yourself on running a growing, successful small business. Unlike that corporate job that led you to go out on your own in the first place, you pride yourself in taking care of your employees, and your employee handbook reflects your commitment to those employees. But there is one tiny, seemingly harmless clause in that handbook that could potentially be exposing you to tens of thousands of dollars in legal fees. And it's a clause you probably borrowed because you took your employee handbook from some other companies, or you wrote it yourself and you're not aware of all the legal nuance, or it just came from a template handbook. Maybe you paid online some really low price to get your employee handbook done, and you've never thought twice about it. My name is Maritza Shea Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that legal stuff might come back to bite them. And today's legal stuff, I'm talking about pay secrecy. It's that very common, often very explicitly written company rule. Don't talk about your salaries or bonuses with your fellow coworkers. As an employer, you might feel like it helps with morale, it prevents jealousy, it helps to maintain privacy. You want your employees to come to you with any issues or concerns that they might have instead of gossiping with each other. But what if I told you that this one rule, something you think is just standard operating procedure, could be the single biggest red flag in your employee handbook? It's a common mistake that I see my small business clients make over and over and over again, and it comes down to a law that's about 90 years old at this point. The legal shock for most small business employers is rooted in the National Labor Relations Act, or the NLRA. The NLRA governs the relationship between private sector employers and their employees. And one section, specifically Section 7, grants employees a massive federally protected right, and that's the right to engage in concerted activities for the purpose of mutual aid or protection. So what is that? What counts as a concerted activity? What can your employees do for their mutual aid and protection? Well, it includes efforts by your employees to improve the terms and conditions of their employment. And what's the biggest term and condition of employment? That's right, how much everybody gets paid. So when you put a rule in your employee handbook that explicitly prohibits your employees from discussing their pay, their bonuses, or other compensation, then the National Labor Relations Board views that policy itself as a violation of Section 7, even if you never actually try to enforce it. The mere existence of the rule in your handbook unlawfully chills your employees' federally protected right to organize and discuss their wages. It's an automatic red flag for the NLRB, and it can expose your business to significant liability. So what do you need to do right now? You need to audit your policies. Based on best practices for employee handbooks, here's exactly what you need to look for and remove or revise. The first thing is look at your confidentiality clauses. You want to look for those very broad confidentiality clauses in your employee handbook, or maybe in a separate confidentiality and proprietary rights agreement that defines confidential information to include employee wages, benefits, or bonus structures. How do you fix this? You include a clear carve-out. Your confidentiality policy obviously should protect trade secrets, client lists, your intellectual property, but it must also explicitly state that the policy is not intended to restrict an employee's right to discuss their wages, their hours, other terms and conditions of employment that are likely protected under Section 7 of the NLRA. The second thing you're going to look for is your general conduct policy. Somewhere in your handbook, you probably have general standards of conduct, policies that prohibit disruptive behavior, unproductive behavior, or even gossiping. Those things could all be interpreted as covering wage discussions, right? I mean, the reason you put that rule in your handbook in the first place is you didn't want employees to be disruptive at work, talking about who's getting paid how much, or gossiping about their pay versus somebody else's. So how do we fix this? We make sure that these policies are narrowly tailored to your true business needs. And in other words, why is it that you want your employees to keep this a secret? It's not enough just to say, I think they're going to gossip and turn into, small toddlers or children on the middle school playground, but really focus in on what is it that you really need to protect. Those things, yes, we want to protect in your confidentiality policies, but we don't want it to be interpreted as banning these protected concerted activities. Vague language is the enemy here. You might mean well, but as a good mentor of mine always said, No good deed goes unpunished. The third thing we're going to look for are your non-disparagement provisions. These especially come up in severance agreements. So we want to look for those non-disparagement clauses that could be considered overly broad. A recent NLRB decision called McLaren-McComb reinforced the idea that severance agreements that broadly prohibit employees from disparaging the workplace, right? That could be interpreted as you can't talk about your wages, you can't talk about hours, you can't talk about working conditions, you can't talk about disputes that you have with me as your boss, right? That type of broad, don't say anything bad about us is unlawful because it can have that chilling tendency on the employee's ability to exercise their rights under the NLRA. So, how do we fix this one? Any of your non-disparagement or confidentiality clauses, especially those that might be in a separation or severance agreement, need to have a specific qualification to preserve the employee's Section 7 rights. So that's a lot. What do we do next? The big thing is don't wait for a demand letter or a formal charge from a disgruntled employee to find out that your handbook is illegal. This mistake could easily cost you tens of thousands of dollars in legal fees just trying to defend your employment practices. And if your handbook already makes this one mistake, chances are that that plaintiff's employment attorney that's representing that disgruntled employee is going to find other costly legal mistakes to harp on. So take action today. Review your employee handbook. Review those confidentiality agreements. If you have a severance agreement or a template for one that you sometimes use, take a look at that too and do it now. But if you're not sure, don't guess. Schedule a consultation to ensure that your policies are protecting your business, but are also compliant with federal laws like the NLRA. The cost of a review is nothing compared to the cost of litigation, and oftentimes litigation is brought by that disgruntled, especially disgruntled former employees. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and you want to build something amazing or take amazing to the next level, then let's talk. Check out the link in the description to schedule a consultation.